Welcome to Chapter 7 of Business Laws, Intellectual Property and Technology Law. I'm your instructor, and in this module, you'll gain not just theoretical knowledge, but practical skills to identify, protect, and leverage intangible assets in the digital age. We'll explore how creative effort and technical know-how become valuable legal assets, and how you can turn legal frameworks into business advantage. By the end of this module, you will be able to identify and protect different types of intellectual property, navigate filing and enforcement procedures, implement compliance and risk management strategies, and understand the interplay between various IP rights. You'll also learn to apply legal frameworks to real-world business scenarios and use actionable checklists for patents, trademarks, geographical indications, copyright, and digital assets. This course is designed for business professionals who want to turn legal knowledge into practical advantage. You'll analyze real-world scenarios, assess risks, and apply step-by-step procedures to protect inventions, brands, creative works, and data, especially in the Indian context. Intellectual property law turns innovation into excludable rights, while technology law governs our digital infrastructure. Together, they answer 5 critical questions every organization faces. Who owns what? For how long? Under what conditions may others use it? What remedies exist when rights are infringed? And how must leaders govern data and algorithms responsibly? Throughout this module, we'll break down complex rules into practical managerial checklists you can implement immediately. You'll see step-by-step procedures for filing patents, registering trademarks, protecting designs, and managing digital assets, all tailored for the Indian business environment. We'll cover 8 major areas: patents, designs, trademarks, geographical indications, copyright, digital assets, cybersecurity, and AI governance. For each, you'll gain practical examples, compliance strategies, and enforcement playbooks to help you avoid common legal pitfalls and drive innovation. This module is grounded in Indian law and practice, ensuring you can implement what you learn in your organization right away. Let's begin with the foundation, the Patents Act of 1970, and build your expertise step by step. A patent is a time-limited, territorially confined negative right. The owner can exclude others from making, using, or selling the claimed invention in India for 20 years from the filing date. India protects products and processes that are new, involve an inventive step, and are industrially applicable. However, important exclusions exist: mere discoveries, business methods, and computer programs per se. Software-related inventions may qualify when claims tie to technical effects, like improved hardware resource allocation or novel sensor control. Technical implementation is key. 3 main filing routes exist: provisional to complete within 12 months, Paris Convention for International Filings, or PCT for extended international protection up to 30 months. Critical deadlines include request for examination within 48 months and responding to first examination reports within prescribed periods. Missing these deadlines can be fatal to your application. Opposition can occur pre-grant by any person or post-grant by interested parties. Well-prepared affidavits, expert declarations, and claim charts are decisive for success. Annual Form 27 declarations are required, showing how patents are worked in India. Non-working can lead to compulsory licensing after 3 years from grant. The Designs Act 2000 protects visual appearance, shape, configuration, pattern, and ornament. Unlike patents, designs protect appearance, not function. File before disclosure, submit complete view sets, and consider multiple embodiments. Design protection lasts 10 years, extendable by 5, focusing on overall visual impression to informed users. Trademarks are signs capable of graphical representation that distinguish goods or services. Registration creates a renewable 10-year statutory monopoly to prevent consumer confusion about origin. Absolute grounds bar descriptive terms, laudatory expressions, and scandalous matter. However, acquired distinctiveness through use and advertising may overcome certain objections. Enforcement includes infringement suits, interim relief, customs recordal, and platform takedowns. Well-known marks enjoy broader protection, even across dissimilar goods. Geographical indications identify goods originating from specific territories where quality or characteristics are essentially attributable to that geographical origin. Registration requires a comprehensive dossier, statement of case, territory map, production specifications, and inspection structure. Only associations or representative organizations may apply. Protection covers direct misuse, unfair competition, and translation variance. Enforcement includes civil suits, criminal penalties, and border measures through customs cooperation. Effective GI management requires independent inspection bodies, strict specification control, and comprehensive labeling with traceability systems including QR codes and batch numbers. Consider Darjeeling tea, reputation tied to altitude and climate with robust global protection, or handloom clusters where traditional patterns receive GI protection against copycat prints. Copyright protects original expression in literary, dramatic, musical, and artistic works, plus computer programs, films, and sound recordings. Remember, ideas are free, but expression is protected. The author is typically the first owner, but employment creates exceptions. For works made during employment, the employer usually owns rights unless contracted otherwise. Economic rights include reproduction, adaptation, and public communication. Moral rights, paternity and integrity, persist even after assignment and require explicit waivers. Infringement requires substantial similarity assessed qualitatively and quantitatively. Access plus similarity often infers copying, but independent creation provides a complete defense. Computer programs are literary works. Understand license families. Copyleft like GPL versus permissive like MIT. Maintain a software bill of materials and approval workflows. Online enforcement combines notice and takedown procedures, watermarking, fingerprinting, and dynamic court injunctions that track mirror sites across the internet. India regulates virtual digital assets through tax, foreign exchange, and anti-money laundering channels. A flat tax rate applies with 1% TDS above thresholds affecting liquidity models. VDA service providers must implement robust KYC, monitor transactions, file suspicious transaction reports, and maintain detailed records for regulatory compliance. For NFTs and branded digital assets, avoid financial return language unless prepared for securities scrutiny. Clearly define license terms, display rights versus commercial rights, and secondary market policies. The Information Technology Act 2000 recognizes electronic records, creates cyber offenses, and provides safe harbor to intermediaries following due diligence rules. Critical obligations include incident reporting to CERT-in within tight timelines for malware attacks, data breaches, and infrastructure incidents. Maintain proper log retention and time synchronization. Intermediaries must publish terms, act on lawful takedown orders, retain prescribed data, appoint compliance officers for significant platforms, and maintain user grievance workflows. The Digital Personal Data Protection Act, 2023, creates a modern privacy framework centered on consent, notice, purpose limitation, and individual rights, supervised by a data protection board. Key players include data principals, the individuals, data fiduciaries, organizations deciding processing purposes, and data processors, entities processing data under contract. Compliance requires free, specific, informed consent that can be withdrawn. Significant data fiduciaries must perform impact assessments, appoint protection officers, and undergo independent audits. AI liability operates through negligence for unreasonable design, product liability for defective systems, and vicarious liability for employee misuse within scope of employment. AI governance requires fairness to avoid disparate impact, transparency proportionate to risk, robustness against attacks, and clear accountability with named model owners. Implement human oversight for high-stakes decisions, A/B testing before deployment, drift monitoring, adversarial testing, and fallback pathways when confidence is low. Successful IP management requires systematic approaches: invention, capture programs, prior art searches, filing strategies, deadline management, and enforcement playbooks. Coordinate all IP rights, patents for technical solutions, designs for appearance, trademarks for brand identity, and copyrights for creative expression into a coherent protection strategy. Intellectual property and technology law provide the foundation for protecting innovation and managing digital transformation. Implement these frameworks systematically to build sustainable competitive advantages. This concludes Chapter 7 on intellectual property and technology law. Apply these principles in your organization, maintain compliance with evolving regulations, and remember, proactive IP management is strategic business management.